The Honourable Phil Goff.
Mr Chairman, the Labor Party supported this bill on its introduction, and it continues to support the bill. I think this bill makes small but useful changes to the major piece of reform legislation in this area, which was the parole bill in 2002, which I'm very familiar with. And I've got to say, when we look back over the period of 12 years that have elapsed since that legislation went through, I'm very pleased with the results of the Parole Act of 2002. The regulatory impact statement for this bill states clearly that consequent upon the passage of the Parole Act in 2002, the number of offenders on parole that re-offended while on parole halved. Mr Bakshi talked about the importance of victims. There's nothing more important than stopping a person becoming a victim in the first place. And the Parole Act in 2002 not only halved the number of people offending on parole, but it also halved the seriousness of the offences that were committed. Both of those points made in the regulatory impact statement. And it was successful because we built into the Parole Act the principle that the safety of the community had to be the paramount consideration for the parole board. The parole board was not to act in a way that would have subjected the community to undue risk. And I guess I copped a bit of flack from the Minister of Finance at the time that I passed this bill through Parliament, because the number of people in prison the numbers in prison went up because people were staying there longer. But it did have an impact, and I don't think anybody would doubt that that Act has been effective. Now, the Act has also been effective because of the very really good way in which the Parole Board has operated. First under Sir David Carruthers, and I acknowledge the work that David Carruthers has done in this and so many areas. I think he's made a massive contribution to our justice system. But before the Select Committee looking at this bill, sir, you'll remember, because you're on the committee, that we had Justice Warwick Gendel before the committee and former High Court Judge, the Honourable Marion Frater. It was interesting that in those making submissions on this bill, ranging from the Sensible Sentencing Trust at one end to people who wanted to reform prisons on the other, that all had a good word to say about the way in which the Parole Board operated. And I think most members of the committee actually had the unique opportunity as an outsider to sit in on the Parole Board hearings. And I sat in at Auckland Women's Prison, a couple of cases where the person applying for parole were murderers, but I was incredibly impressed at the way in which they conducted themselves. So I think we've got a system that has worked really well, good people and good law. But after 12 years there was a need to change, and the predominant change that this legislation makes is to change the clause in the original Act that required parole hearings to be held within 12 months. And that meant generally they were held after 11 months. And it also meant that there were a lot of people who simply were never going to be paroled on the first or the second or the third time they were up for parole. The offender knew that, the victim probably knew that, the system knew that, and we wondered why we were putting people through, particularly the victims, through the unnecessary trauma of fearing that perhaps the person would be released and might be a threat to their safety, and raising false hope on the part of the offender. For about a third of the parolees, they have 4 or more parole hearings before they were released. And it seemed to the Ministry of Justice and it seemed to the members of the committee that that was a sensible change to make. Interestingly, and I refer to the Greens on this because the Greens Minority Report still opposes this legislation, though I don't think vehemently. I think they took a rational view on the committee. The interesting point that came out from the hearings on the committee and from the Parole Board itself was a statement by the Parole Board that this would probably result in people spending less time in prison rather than more time in prison. But Mr Chairman,
Honourable Full
but it would reduce the number of parole hearings by about 800, and yes, that does make a saving of $700,000 odd, but that is not the primary purpose of doing it. The primary purpose of doing it is to have a parole system that works more effectively and efficiently and is fairer to all of the people that appear before it. There are a lot of parole hearings. There's something between 5,000 and 6,000 parole hearings a year, and that obviously does impose a lot of pressure on the Parole Board and the people that service that board. So the major change in this legislation that is sensible is that it gives the Parole Board itself the ability to extend the time between hearings to up to 2 years. And that will result, as I said before, not in people spending longer in prison, but in people having to attend fewer Parole Board hearings before they are actually released. And it did not make sense to have somebody who had not yet completed their rehabilitation program to appear before the Parole Board when the Parole Board knew, and they knew that they hadn't completed the program, they hadn't dealt with the causes of their offending, and they weren't going to be released. That was just time consuming, it interrupted the rehabilitative programs, and it served no purpose. In the original legislation, we recognised that there would be some people that simply weren't going to be ready for release on parole, and therefore we allowed for the existence of what was called a postponement order, which meant for people serving determinate sentences, there could be a 2-year postponement between parole hearings, and for people on indeterminate sentences, life sentences or preventive detention, it could be up to 3 years. Consequential upon the change of giving more flexibility to the board to vary the period between hearings, postponement orders now will largely deal only with indeterminate sentences and with determinate sentences of more than 10 years. And in this case, it allows for the period between parole hearings to be extended for as much as 5 years. And Mr Speaker, I've got to say that having been through every prison in the country and thinking that, you know, there is hope in most prisons, that people can change, that people can be released, that the people there aren't necessarily ogres. There is one prison where I had a totally different view, and that was Paremaremo Maximum Prison. And frankly, the people I saw in the maximum security wing that were psychopaths, actually it didn't need to be 5 years. There are people there that ought never to be released. And I'm not a person that says lock them up and throw away the key. I think there is redemption in most people, but in some people there is no prospect. They will always be a threat, and that's why it's important to have that postponement order, and that can be and will be used, I'm sure, for periods up to 5 years. The Select Committee didn't make a lot of major changes to the legislation. We did replace the term risk milestone with the term relevant activity. That might seem a bit esoteric to those listening. The real problem with the term risk milestone was that it implied that if you said a person had passed the risk milestone, that assumed that they had succeeded in all of the objectives. And the Parole Board itself said that was not the right term to use because it could be misleading. So we've changed that term. The major recommendation, I bring it to the attention of the Minister because she was not the Minister that we referred the initial advice to, was the information we got from the Parole Board that their decisions could only be as good as the information they received, and quite often they were not being given information on civil protection orders that were, because they were civil, weren't within the criminal system, and they weren't aware of things that they should have known about when they were considering a person for release on parole. So if I can use this opportunity, Minister, just to draw that specifically to your attention, as I think as Jacinda Ardern did, and say, really across the board in the Select Committee, it wasn't a partisan issue, we felt that that was an issue that needed to be addressed by your ministry, and we hope that, that action is taken on that. But apart from those two things, there were no major changes that were made. I draw to the House's attention that there can be early consideration for parole. You can bring parole hearings forward in cases where that is justified.